So, friends, there are at least three reasons why Donald Trump's apparent violation of the Espionage Act must be prosecuted. Let's talk about those three reasons. And actually, there's a fourth reason. Because justice matters. Hey all, Glenn Kirshner here. So the Mar-a-Lago search warrant has been unsealed, and we didn't get to see everything, but we got to see some pretty important stuff. We got to see precisely what crimes the Department of Justice is investigating, what crimes Donald Trump may have committed, what crimes the DOJ believed they would find evidence of on the property at Mar-a-Lago. If we look at attachment B to the search warrant, here's what they were searching for. All physical documents and records constituting evidence, contraband, fruits of crime, or other items illegally possessed in violation of 18 United States Code 793, Section 2071, or Section 1519. Those are important numbers. Let's do Donald Trump's possible crimes by the numbers. Let's start with 18 United States Code 2071. That involves the unlawful removal of government documents. That is only, I shouldn't say only, because I wouldn't want to spend 3 minutes in prison, never mind 3 years, but that carries a maximum prison term of 3 years. But even more importantly, it includes a possible lifetime ban from holding federal office. So that's important when we're talking about Donald Trump. The next crime is 18 United States Code 1519, concealing records to obstruct an investigation. That's a 20-year federal felony. That one feels like it's going to be pretty easy to prove because we learned that they negotiated with Trump to get the documents back. He wouldn't give them all back. They met with him at Mar-a-Lago. He wouldn't give them all back. They subpoenaed them, and he violated that subpoena. And that's what constitutes obstructing justice by concealing records, a 1519 offense, up to 20 years in prison. And then there's possible espionage. We're going to talk about this one for a few minutes. So let's talk about the Espionage Act. One of the statutes, one of the federal laws that implements the Espionage Act is 18 United States Code Section 793. And that outlaws gathering, transmitting, or losing national defense documents. Whether they're classified or not, doesn't matter. Whether they pertain to nuclear weapons or not, doesn't matter. And that is a 10-year federal felony, and violating that constitutes espionage. So I think we have to talk about why we prosecute people for espionage. Well, generally, we prosecute people to hold accountable the wrongdoer, to punish the wrongdoer. We prosecute people to protect the public safety. And we prosecute people to deter others from engaging in the same or similar criminal conduct. And that deterrence goal is about as important as it can be when you're talking about crimes that involve espionage. So if the Department of Justice declines, neglects, refuses to charge Donald Trump with that 793 crime, gathering, transmitting, or losing national defense documents, with that espionage crime, if they fail to charge him and prosecute him, they are not only not discouraging espionage, there's an argument that they're encouraging espionage. Because if Donald Trump gets to do it without being held accountable, why can't others begin to mishandle, remove, conceal, destroy, sell national defense documents? And here is one other problem with failing or refusing to prosecute Trump for his crimes, espionage and others. There's a doctrine called selective prosecution. It's something that I teach to my criminal justice students at George Washington University. Selective prosecution is a defense, and it stands for the proposition that if the federal government, the Department of Justice, refuses to prosecute somebody for their crime, and then they decide to charge and prosecute somebody else for that same crime, you know what the defendant will raise as a possible defense? Selective prosecution. That is a violation of the equal application of the laws, maybe even a violation of equal protection of the laws. And frankly, it's just not right, not fair, and the federal government shouldn't be allowed to do it. If they refuse to prosecute Donald Trump for espionage, then I'm going to raise a selective prosecution defense and say they have to dismiss the case against me for the same or similar conduct. Now, I would hasten to add, proving selective prosecution as a defense is really hard. It's a real uphill climb for a defendant. I could tell a quick story about one of the famous selective prosecution cases, which arose in the Vietnam era as a result of the draft, the Selective Service, and people refusing to register for the draft, non-registrants, because that was a crime if you failed to register for the Selective Service. And there were some 670,000 Americans who failed or refused to register. Of those 670,000, do you know how many the federal government chose to prosecute? 13. Now, there are reasons for that that kind of go beyond the scope of this video today. But those 13 defendants made the challenge that, whoa, we're being selectively prosecuted. 13 out of 674, I think it was, 1,000? Tain't fair. That's not an equal application of the law. And that was litigated, and the Supreme Court ultimately concluded that yes, selective prosecution is a thing, it's a viable defense, but the defendants in that case didn't adequately make out that defense, didn't make their case. So it was rejected, but it is a viable defense to be brought. And you can bet if the Department of Justice fails or declines to prosecute Donald Trump for espionage and his other crimes, every defendant moving forward who is charged with mishandling government documents, classified materials, national defense documents, will forever be making selective prosecution claims, and some may be successful. Is that the country we want to be living in, where Department of Justice policies encourage espionage instead of discourage, deter espionage? Let me say, I don't for a minute believe that Merrick Garland and the Department of Justice are just going to walk away from this, turn a blind eye, just going to let Donald Trump go completely unaccountable for these crimes, these dramatic crimes. We have forever been talking about Donald Trump's January 6 crimes to try to overturn the election's results, to try to kill our democracy. And now we're talking about really a whole new batch of crimes involving his theft of, mismanagement of, removal of, concealment of, top secret, classified, national security, information. And friends, there are lots more shoes that will drop, I am quite sure. Because do you think Donald Trump, once he stole those documents, once he removed them from the White House, he had no lawful authority to do that, whether classified or not, and once he began concealing them at Mar-a-Lago, do you really think he handled them carefully, thoughtfully, with great reverence and circumspect? Or do you think he may have given access to them to people who might not have America's best interests at heart? You think he might have even profited off giving people access or copies of those documents? Oh, we will be learning more about that in the future, because Donald Trump will be held accountable for these crimes. I have long said the Department of Justice has moved too slowly, but I have also long said I can't conceive of a country in which the Department of Justice does not charge a former criminal president with his crimes, with these crimes. This is not Richard Nixon territory. This is democracy-ending territory. Trump and his criminal associates will be held accountable, in my opinion, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.